Hi, everybody. 2 days in a row. Holy cow. Welcome, everyone. For those of you who are not familiar with the channel, my name is Lori Hellis. I'm a retired criminal attorney, and I've written a book about the Daybell story. Welcome, everyone. Good to see people lining up in the chat. Hi, everybody. Good to see all of you folks. I thought I'd just hop on tonight for a short live to talk a little bit about a couple of developments that happened today. First of all, there was a pretrial conference in Chad Daybell's case. Not a huge amount happened, but I thought as long as we were hopping on to talk about the Montgomery case, the verdict, that we could also chat about what happened for Chad. It was primarily a scheduling hearing. There were a couple of outstanding motions that they talked a little bit about. Now, there was a hearing yesterday as well, but it was a closed door session. They were talking about the jury questionnaire and going through the questions that were going to be asked on the jury questionnaire. And those are private conversations. So that session was behind closed doors. And then today there was a public hearing. And at that hearing, they were talking about a fair amount of logistics having to do with the upcoming trial. The judge wanted to get clarity from everyone involved about some scheduling issues, wanted to talk about the sequestration order, and asked John Pryor about the motion he had filed, asking for additional time to identify his experts and their reports. So they started out talking about the sequestration issue. And the judge wanted to make clear that both the defense and the prosecution should be notifying any potential witnesses that they are not permitted to view any of the live stream of the trial prior to their testimony. And, there were a couple of people who, John Pryor in particular, who expressed some concern that there might be people who would purposefully watch the live stream so that they wouldn't have to testify. The judge was clear that that was not a disqualifying, that it wouldn't necessarily disqualify them, but that there would be consequences, and he would be taking it on a witness by witness basis. But both the defense and the prosecution said that they had included with their subpoenas a caution to everyone not to watch the live streams, that they are not permitted to watch any portion of the trial prior to their testimony. So I think they're doing as much as they can. But we saw last time, even though it wasn't live streamed and the audios were released after the trial day, we still saw several people who admitted to having listened to some of the trial prior to coming in to testify. I think it was very clear that Melanie Boudreau-Pawlowski found a way not to have to come and testify. I think that was her motive in listening to Brandon Boudreau's testimony. David Warwick, who's Melanie Gibbs' husband, also said he had listened to some. I think it was more obvious that he sort of forgot about that admonition and was concerned about how she was doing, because they, at least at that point, were living apart. And so I think he was interested in finding out if she was okay. But so the next thing the judge asked about was John Pryor's motion, because he had asked for additional time. Now, there were a couple of creators who erroneously said that John Pryor was once again asking for a continuance. That wasn't the case. John Pryor was asking for additional time past the deadline in order to file his witness list of expert witnesses and make the reports of those witnesses available to the court and the prosecution. He said he did that out of an abundance of caution because he had just received some discovery and he hadn't had the opportunity to look through it and to find out whether or not there was any new, particularly scientific information in the discovery. And so he filed it sort of out of an abundance of caution. He said he had had a conversation with the prosecution. He now realized that there was no new information included with that discovery drop, and he withdrew that motion. So what I've gathered from a couple of different things that have happened is that report is the FBI's CAST report. So we talked a bit about CAST. The FBI has a team that whose job is to analyze cell phone information and to use it to triangulate locations. The process is fairly new. It is really using the same information and applying different algorithms and different rules to the data. And there have been some challenges, scientific Daubert challenges to the data in the past. The data was, all of that data was provided to both Lori Vallow and Chad Daybell. But the Arizona prosecutors have had the FBI specifically apply the CAST formula to it and prepare a CAST report. I'm not quite clear how that worked with Lori Vallow's case. We do know that the cell phone location data was very significant, was very important in her case. And I know it will be in the Daybell case as well. I guess the question is, it really turned out to be form over function, if that makes sense. So although the data was presented in Arizona and provided to the Idaho folks in a slightly different format, it was exactly the same data. So John Pryor withdrew that motion, and the court is going along full steam ahead, getting ready for trial. We're getting jury questionnaires. We're moving ahead right smartly. Now, they talked about timing. The prosecution said they believe that the trial will take every bit of the 8 weeks that they have set aside. So April 1st through May 31st. Remember, this is a death penalty case, so we also have a penalty phase. Although it's likely that they're able to streamline some of the testimony, and John Pryor did address that, both sides addressed it at today's hearing. Lori Vallow's case took 6 weeks, and we didn't have a penalty phase. Penalty phases typically can take as much as 2 weeks. So I think 8 weeks is probably a realistic time frame. However, they did talk about their attempts to streamline the case. One of the things that John Pryor said is that he has many witnesses, many more witnesses than, of course, Lori didn't call any witnesses. So he has already informed the prosecution and the court that he has 7 expert witnesses, and that he expects that they're all going to testify. They did discuss, as it's pretty common in these sort of cases, if the prosecution and the defense both have a witness, the same witness on their witness list, oftentimes what happens is they'll agree that they will usually the rules of evidence and the rules of trial rules say that the person who calls the witness does the direct examination. The the opposing party then has an opportunity to cross-examine a witness. But cross-examination is limited to subjects that came up on direct. So you can't go into things that didn't come up on direct examination. However, oftentimes the parties will agree and the court will agree that the opposing party can ask direct questions on cross in order to keep having to call a witness back a second time. It's inconvenient for the witness and inefficient for the court. So I think you're going to see some of that. We didn't see any of it at Lori's trial because she didn't call any witnesses, but we will see some of that, I think, where we will have some, the opposition is going to, the defense is going to have some substantial leeway to perhaps get into areas that were not raised by the prosecution. So we may see that, a bit of that, and that could streamline having to recall witnesses later for the defense. So, and I think one of the things that they discussed today was the fact that they have reached agreement on a great deal of the trial exhibits, and they're going to stipulate that the exhibits come in. Admitting exhibits can be a really laborious process. You saw it in Lori's trial. I mean, every document from birth certificates and marriage certificates and reports and police reports, and they had to be very laboriously brought in. All of the financial documents, they all had to be very laboriously brought in. It is a painstaking process. So if both sides can reach an agreement on what is going to be admitted without any sort of objection, then that makes it quicker and less laborious, because we're not having to go through laying a foundation for the origin of the document, who compiled it, under what circumstances, when it was done, all of those things. And that's going to cut back on some witnesses. For example, you won't have to call the person who compiled the documents for the school district. You won't have to go through and call the person who compiled the documents for the insurance company or the banks, because those will come in without objection. So that is going to streamline things a bit as well. And of course, we know that both sides have learned a lot from Lori's trial, and I think that's going to further refine the areas that they're going to get into, the areas of inquiry they're going to get into. So the judge adjourned that hearing. It was a fairly quick hearing. The judge adjourned it, and the prosecution did say that they are going to file some motions in limine. We've talked about motions in limine before. What happens is each side is entitled to file a motion in limine and to get the court to make evidentiary rulings ahead of trial. That saves having to do those once the jury is impaneled. And because they're typically arguments you don't want made in front of the jury. And if they're not made in advance, that means that the jury spends a lot of time cooling their heels in the jury room while the judge and the lawyers are arguing about what evidence comes in and what doesn't. So the prosecution has announced that they are going to file motions in limine, and the judge has said, Lindsay Blake said she believed those motions would be filed early next week, and the judge has said that he will set a hearing as soon as possible on those motions. And that makes perfect sense to get those motions heard in advance and pin down what evidentiary rulings the court's going to make in advance of the trial. So I think we'll be seeing a hearing in the next week or two about those issues, and that hearing should be open to the public. There shouldn't be any reason for that to be sealed. There certainly were discussions that were had having to do with jury questionnaire and jury selection that were appropriately done behind closed doors. So now moving on to Adam Montgomery. The jury came back after 7 hours of deliberation and found Adam Montgomery guilty on all of the charges that he was charged with, including second-degree murder of his daughter, Harmony Montgomery. I've told you before, this is a tough case for me. You know, I have been involved in some very difficult cases, and I have been involved in some trainings that have involved prosecuting child murders, and so I'm not a novice when it comes to those really difficult facts and difficult evidence. However, I've also said that my daughter, who is now an adult, is what could have been Harmony's sister. She was a little blonde. She wore thick glasses. She was, and she could have easily been a sibling of Harmony's. And that, for some reason, that case just hit different for me, and I had a real tough time with it. And hearing the abuse that she lived through for the last few days of her life, and then how her sweet little body was mistreated, was, I know, very difficult for everyone. And that one was one that was hard for me as well. So I was happy to see that he was convicted on all counts. I thought it was very interesting that after the verdict was read, the prosecutor said to the judge, there is a specific statute that says that Adam Montgomery must be present for his sentencing. And so we expect that he will be present for sentencing. The judge was having difficulty finding a date on her calendar because she is about to start yet another lengthy homicide case in April, and was finding it difficult to find a date. They did not ask for a pre-sentence investigation. The prosecution didn't feel they needed one. And the defense didn't ask for one either, probably because they were pretty sure that it would be even more damning than the information that came up at trial. So no one seemed to see any need for that. But the judge did say that she was going to have difficulty finding time to do that because she's in a couple of extended trials. And it appears that they're not looking to sentence him until May. So he will continue to be in the local jail, and they will hold him until his sentencing, which looks like it's going to be sometime in early May. So I'm kind of keeping my fingers crossed that Chad Daybell's trial is going to be finished before CRIMECON starts on May 30th. But if it doesn't, it doesn't. You know, Lori's trial, the verdict came in while I was at my daughter's wedding. So, you know, we go with the way things work out. For those of you who may not have heard last night, we also have a big announcement because my book is live. So if you are inclined to do so, please pre-order your copy. I have checked the live links at the major retailers. It is live on Amazon and Barnes & Noble both. I I don't think that it's live on Bookshop yet, but I will check again. When I checked yesterday, it had not gone live, but it's a function of my publisher, so I don't have anything to do with when they activate those specific order links. But it is live on Amazon and Barnes and Noble both. And I want to say thanks to all of you who have already pre-ordered. It's amazing. And just in 24 hours, we're already seeing the book creep up in the Amazon standings. So I'm super excited about it. Please, please consider pre-ordering. It does do a world of good for authors when you pre-order books. So there is a link in our show notes. So please, if you are so inclined, order your copy. Once we go to CRIMECON, we are going to be at CRIMECON. We are going to be giving out book plates, autographed book plates to anyone who proves that they've pre-ordered. And we're going to have some other goodies to hand out down there. But anyone who has pre-ordered certainly is going to get a book plate. Also, we are starting the book launch team. So the first, and that website should be up and live next week. And we are going to be launching that for the first 100 people who join the Book Launch League. And that is our team is going to be made up of people who will receive an advanced digital copy of the book. And in return, we will be asking you to post reviews on both Amazon, Barnes and Noble. I will have links out for all of the review sites. And we'll be asking you to post a picture of yourself on social media with the book, and especially in the Good Lori Facebook group. So we also have some exciting news for those of you who have been waiting to hear this. And I know this is a repeat for some of you, but as you all know, I'm a quilter. And we did a really fun quilt-along project, and then raffled it off for charity. We raised some money for the Center for Missing and Exploited Children, and our very own Arizoni, who is in the chat, I believe, was the recipient of the True Crime quilt. And so the next project is to do a quilt for Kay and Larry Woodcock. And TERRI Goyins, who quilted the True Crime quilt, has offered to quilt this one as well. And in Japan, it is a tradition to fold origami cranes in memory of someone who has passed away. And so we have an origami crane quilt pattern, and you can download the pattern. The link is in our show notes, and it is a link to a Google document in my Google Docs, and it will give you the pattern. This is a paper-pieced pattern. For those of you who are not familiar with this or would like to try your hand at it, I'm going to post an instruction video. Essentially, what you're doing is you're using a pattern printed on paper that you are using to sew over the top of. It's kind of like paint by numbers, and it's super fun. It gives you these nice sharp points and these very nice sharp definitions. And so the only thing I'm asking is that when you create your block, please use a black background, and then use any color you like for the crane on the middle, on the inside. This one in particular is kind of a pale pink. Doesn't show up so great on my camera, but we will post some photos so you can all see what's going on. And I'm definitely going to have an instructional video up very shortly for you. Probably work on that this weekend. So that's going to be super fun. I I'm happy to take some questions if anybody wants to chat about what's been going on and on those two cases. Jane Blackbird, this is a very good question. How in the world is Chad paying for 7 experts and all the expenses that involve? I think this is a good question, and the answer is no one really knows. I think it's possible that he is getting some help, potentially from family, although I don't know whether that's true or not. I do know that his family, his children, and his parents have continued to be pretty firmly behind him. I also have heard, and I don't want to I don't want to say that this is fact. I speculate, and I have heard rumors that there are some people who are still firmly following him and following the Deseret doomsdayers who have been helping him with his expenses. I have heard that. I have not been able to confirm any of that information, but I have heard that that is the case. Thank you, Kara J. I appreciate your support. Thank you so much. So we don't know for certain, but I think we could speculate that he's getting help somewhere, and it may very well be from some of his better healed adherents. So we do know that there are still people very firmly in the Deseret Doomsday camp, folks who were preparing a people, followers who are now big followers of the Firm Foundation, which is sort of the organization that took over for preparing a people. We know that there are still plenty of people who are subscribing to the Avow website and are active on that platform, as Chad was. And those are all, I think, places where people could potentially be supporting him. So I don't know, because John Pryor did say that he is concerned about the expense of experts, and if they possibly this is a great question, and I'm going to answer it. John Pryor expressed concerns at the hearing about what might happen if the trial got delayed and he ended up having to fly experts in and then have them turn around and come back. So he's definitely concerned about the expense of the cost of experts. And believe me, experts do not testify for free. So there's money coming in somewhere, but we just don't know where yet. Maybe we'll find out. Maybe we never will. I don't know. Guilty of crime. This is great. Catching alive. Do you think they will possibly take a plea deal, or maybe the state isn't offering one? So here's what I can tell you that I know for certain. I know for certain that the state has offered a plea deal. And I know for certain that the state has offered Chad the same as Lori. I also know that Chad has declined that offer because he doesn't believe that he is guilty of anything. And he is insisting that the only way that he will. Now, I've heard this. I have not confirmed this with any of the parties, but what I've heard is that he is not willing to enter a plea to anything other than time served. And that certainly is not going to happen. So he is still adamantly saying that he doesn't believe that he did anything wrong and that he is not guilty. I think he has been able to really throw Lori and Alex under the bus when it comes to the children. Even Lori, in sort of a roundabout way, threw Alex under the bus when it comes to the children. However, it is going to be much more difficult for him to explain Tammy's death, since he and Garth were the only two people in the house. I mean, I think the only thing I can imagine that he is going to do is to continue to say Tammy died of natural causes. That clearly isn't the case. The medical examiner, if you watch Lori Vallow's case, the medical examiner was very unequivocal about their opinion about the cause of Tammy's death. She was suffocated. So somebody put the pillow over Tammy's face, and Chad and Garth were the only two people in the house. Now, we do know that Alex Cox's phone pinged a mile or so up the road that evening in the church parking lot. So one of two things happened. Either Alex was up there sort of to be Chad's backup in case Chad couldn't go through with it, or Alex walked down, snuck into the house, and did the deed. Either way, there's no way Chad wasn't part of that conspiracy. So I don't see how he begins to get out of that. So I think he's being incredibly unrealistic. I think he is absolutely, his expectations are through the roof, and that is always very difficult for an attorney. Managing your client's expectations is always very difficult. So I don't know, but it seems to me that that at this point, the prosecution, I happen to know that as recently as a couple of weeks ago, there were plea discussions going on, but I don't think we're anywhere close to coming to a meeting of the minds. So I don't see a plea happening. Sorry for the scratchy throat tonight. I don't know what that's all about. Tennis girl. Well, yes and no. The question is, can he get state funding for anything since he is indigent? So what we found out when John Pryor filed his motion to withdraw, we found out that, in fact, he had presented information to the court, and the judge had made a finding of indigency a year ago in January. So we know, and at that point, the judge told John Pryor that he would authorize payment through the state if John Pryor could find a death penalty qualified lawyer to come alongside him. And John Pryor wasn't able to make that work. So he hasn't been able to find somebody. There is a real shortage of defense attorneys, especially in the more complex cases. We know that there's a shortage nationwide. And we certainly know that there has been a shortage in Idaho, because we've heard in a couple of different cases that there's been difficulty in getting defense attorneys. The most recent case, and I'm going to, whoops, wrong. Let me just pull it up because I have trouble remembering this guy's name. I don't know why. Jeremy Best. That case, they was a real challenge to find death penalty qualified attorneys out in Canyon City. And Canyon City only has one attorney in the DA's office, the elected DA. And so they have recently hired Rachel Smith to come in and consult with them on that case for the state. So the judge did declare Chad indigent, and he did approve Chad receiving state paid second attorney. Whether the judge has also approved the expenses for experts is unknown at this point. But it's possible that the judge has approved at least some experts. I think it's really interesting that that we heard during the time that John Pryor was during the hearing where he was asking to be relieved, a conversation about the fact that under the Idaho law, attorneys who are death penalty qualified because they're qualified to be paid public defenders um, are required to follow the American Bar Association guidelines for death penalty lawyers, including the guideline that they hire a mitigation specialist. However, the ABA guidelines are not mandatory for a person who is retained. And so John Pryor has declined to hire a mitigation specialist. At least that was the impression that was given during that hearing. Because that information goes to trial strategy, the judge was cautious not to delve too deeply into that, but the judge did remark, we understand your position on not needing to hire a mitigation specialist. So that's interesting too. The mitigation phase could be fairly short because a mitigation specialist generally investigates the defendant and their family going back 3 generations and investigating everything from medical and mental health history, work history, military history, you name it, they go through it. So it is surprising that that sort of work is not being done in Chad's case, at least not on that scale. So the answer is we don't know. Was Chad officially excommunicated from the church? Yes, he was. And that information came out in public. The church does not make public their excommunications or disfellowships or whatever it is they're calling it now to make it sound less draconian. They don't release that information, but that information did come out, and there was a copy of the letter that was sent to Chad that made the rounds on social media. We don't know whether Lori Vallow was excommunicated, although we must presume so. Everybody who is sort of close to the case presumes that she was excommunicated as well. So good questions, guys. And I will sort of give a little teaser about the book. My book delves quite deeply into the influences that impacted the religious influences that impacted Chad and Lori and their followers. So there is a pretty deep dive into those issues. Shelley's Flowers. Do you have any information about Melanie Gibbs, Serena, Melanice, April, etc.? Not a lot of current information. The last we really heard much about Melanie Gibb was at Lori's trial. She was living in Arizona. Her husband is living in Utah. They're living apart supposedly because Melanie has a disabled son that she's helping with. Serena, we have not heard anything about. Melanice has been keeping a very low profile. And we have not heard a great deal about her. We've seen a bit about Brandon Boudreau and his second wife and family. He still has primary custody of his children with Melanie Boudreau Pulowski. And it will be interesting to see whether or not she is subpoenaed for this trial. She was subpoenaed for Lori's trial, and then they discovered that she had been watch or listening to the trial afterwards. And so they were very hesitant to put her on the stand, and in fact decided not to call her and called Ian Pulowski, her husband, instead. So, and I think they got some decent information out of his testimony. So it probably was just as well. Lori's name is off the records of the church, so that means she's excommunicated. Thank you, Ducker. I don't have access to those records, but I'm sure that people who do, there are folks in the chat who do, and I appreciate knowing that. I think we all presumed that, particularly after we found out that Chad had received his excommunication letter, and that was prior to any of the trials. So I don't think it was really much surprise. So. Hi, Annie S. I hope this is the Annie S from Rexburg, or that neck of the woods. Hi there. Hope you're doing well. Do you think Chad and Lori will stay married? You know, I don't know. I do know that the marital privilege in Idaho does not apply to spouses if abuse or neglect is charged for the children of one of the spouses. You can't claim the marital privilege if the issue you're being asked about is the abuse or neglect of the other person's child. So there was no marital privilege exception for any testimony having to do with Lori's children. There could be marital privilege having to do with Tammy's death. So I don't know, because I don't think I don't believe that they're going to call Lori as a witness. Certainly she still has criminal matters pending in Arizona involving the attempt on Brandon Boudreaux's life and Charles Vallow's murder. Now, those don't necessarily have direct relevance with the death of the children or Tammy, but I think there's enough overlap that a court would probably rule that her Fifth Amendment right against self-incrimination was still in effect. And so I doubt we'll see Lori as a witness. I could be surprised, but I doubt that we'll see her as a witness. It's clear that if they were to call her, there would have to be some very clear parameters around what could be asked and what could not, because of her liability still in Arizona. So that would be a dicey examination. I think it's possible that John Pryor could try and call her as a rebuttal type witness, but we'll see. As far as them staying married, I absolutely believe Lori is still all in. Whether Chad is still all in or not, I think remains to be seen. But we certainly have seen every indication that Lori is still all in on Chad. And she definitely wants to be called Daybell. She wants, and I think she's writing the court's order saying that they couldn't communicate with one another is no longer effective. Nobody's asked for another one of those orders, so they are free to communicate with one another, and I suspect they have been. I'm sure the prosecution wants them to communicate like crazy with one another, because I'm sure that they're hoping that they're going to make some. Thank you so much, Kathy. That's very generous of you. Thanks a lot. I think that the prosecution's hoping that they communicate like crazy, because I think they're hoping that they'll make some incriminating statements back and forth. So certainly they are able to correspond with one another, probably have phone calls, and we'll see what comes of that. If I had to guess, I would say Chad is probably not as all in on Lori as she is on him, but I think it still remains to be seen. I don't think you'll see divorce coming from Lori's direction, but you might see it from Chad. Although it's not like either one of them is going to run out and get remarried, since they're both going to be in prison for the rest of their lives. Catlink, when did Brandon get primary custody? ISTR, a last minute agreement for shared custody after she had a few supervised visits. I surprised everyone at that time. Okay. Oh, it surprised everyone at that time. So I believe what happened was Brandon filed for custody, and Melanie did not show up for the initial award of custody, and Brandon was awarded custody. Then I believe that Melanie did file an action to sort of review that custody. And I think in mediation, they did reach an agreement. But let's remember that there really are different sort of phases of custody. So legal custody, meaning the parent who has legal decision-making for the children, can be joint, but the children's primary home can be with one or the other of the parents. It's my understanding that although they have joint decision-making about the children primarily live with Brandon and visit with their mother. And it is true that I believe she is permitted unsupervised visitation at this time. So they're required to consult with one another and to discuss decision-making having to do with the children, which, typically is non-emergency medical treatment, whether or not the children are going to go to public or private school, some other of those decisions that they're required to consult with one another on. But when it comes to where they go to bed at night every night, that may be a slightly different arrangement than what we think of as physical 50-50 custody. So my understanding is that they are primarily with Brandon and his second wife. And she has children, I believe, from a prior relationship, but I don't believe they have any children together, at least not yet. So good questions, all. It's going to be fascinating to see what happens in the Harmony Montgomery sentencing. He is, Shelley, I will get to that in just a second. I think it'll be very interesting to see what happens in the Montgomery sentencing. Like I say, I don't think we're going to see that until sometime in May. It will be fascinating to see whether or not he is forced to come to trial. He was not facing the death penalty because the state of New Hampshire outlawed the death penalty in 2019. So, and more states are outlawing outright or suspending, putting a moratorium on death penalty cases. In Oregon, there is a moratorium on executions, and the outgoing governor commuted the sentences of all death penalty cases to life in prison without parole. So there is no one on death row in Oregon right now. A lot of states are following suit. So I think we're going to see some substantial changes. That question was, do I ever miss defending cases? I sometimes. I did recently, for those of you who aren't aware, our move to Idaho was always intended to be temporary. I have one daughter. She has been living in the LA area, got married last spring, and was trying to figure out where they were going to land permanently, because unfortunately Los Angeles these days for a young couple starting out really isn't sustainable. So they're very excited because they have decided to move to Bend, Oregon, back home where my daughter was raised and where I practiced all those years. So her dad and I have decided that we're going to follow, because I'd like to be that grandma. I'd like to be the grandma who lives in the neighborhood and can take care of the kids while mom works a couple of days a week. And I want to be that grandma. So we're looking to move back to Bend in the fall. My daughter's sort of shooting for late summer. And in preparation for that, I recently asked to be taken off of complete inactive status with the Oregon Bar, so that I can volunteer with the Innocence Project, because I would very much like to do that. So I don't think that I'll be doing any courtroom work anytime soon, and I don't think that I'll be doing any paid work, but never say never. But I do anticipate that I'm going to do some pro bono and volunteer work back in Oregon again. So, and I'm excited about that. But I think it's hard to retire. I mean, I never intended to fully retire. I intended to retire to write. Now that this first book is out in the world, I hope that it's well received, because I'd like to continue to write. And I'm very interested in continuing to write true crime. So a little bit of volunteer work and continuing to write true crime, I think, are what's in my future. So, but thanks for asking. I do miss it. I think what I miss more than anything else are my colleagues and friends that I practiced with. And so I'm excited to getting back to Bend and being able to renew those friendships on a closer basis and see those folks more often. So, question from Kara J. If Chad blames the deaths on Lori and Alex in his trial, do you think Lori may change her strategy in Arizona, even though Chad doesn't have any charges there? Well, it's possible. I don't think the prosecution had ruled out charging Chad. They just didn't believe that on the strength of the evidence they had at the time, that they had enough evidence to charge Chad. There's no question that he was sort of flitting around on the periphery, but they were cautious enough to have a lot of conversations by phone and not by text message. So there weren't a lot of messages that connected Chad to the conspiracy in Arizona. So, but who knows what's going to turn up as a result of Lori's trial. And, you know, I mean, I think there's always the chance that if Chad throws Lori under the bus, in the Idaho case, that Lori could very well say turnabout's fair play and do the same to him in the Arizona case. I don't expect it, because I think Lori is still absolutely all in on Chad. I think she still believes he is a prophet, and I have every reason to believe, from everything I know and everything I've heard, she is still firmly in her religious delusions. She still believes that she is a goddess and Chad is a prophet and Jesus is coming back soon, and everyone needs to be prepared. And I think that she honestly believes that, just like the Apostle Paul, the earthquakes on the Wasatch Front are going to happen, and the prison walls are going to collapse, and she's going to walk out a free woman. So there's that. I just think I think that remains to be seen what is going to happen. Could recent phone calls from jail come in at the trial? Absolutely. Absolutely. They're all being taped, and they absolutely will come in. If there is anything incriminating going on between Lori and Chad, we will hear about it at Chad's trial. Yep. You know, I think it's important to remember that I did. It's important to remember that trials are investigated right up until the day that they start taking testimony. And so evidence could turn up before Chad's trial, such as jail calls, and could be used at trial. Idaho Carol, I did see Lori flirting with her Arizona lawyer at the hearing. Poor guy. What was really interesting to me was at that hearing, she had two lawyers. She had a woman lawyer sitting on her left and a male lawyer sitting on her right. The woman lawyer currently is bald, which probably indicates that she is undergoing some sort of chemotherapy treatment. And she virtually ignored the woman. She never acknowledged she was sitting there, never acknowledged her presence, and focused all her attention on the more attractive male attorney sitting to her right. I thought it was fascinating. She also spent a lot of time looking back over his shoulder at the camera, making eye contact with the camera. The other thing I found really fascinating was when she came into the courtroom, still in her shackles, she walked past, sort of flipped her hair and walked past the prosecution's table and gave them a little bubbly little hi as she went by, which I thought was fascinating. So, yeah, there's no indication that there is any change in her. She still is the same self-absorbed, egotistical narcissist that she was a few months ago at her sentencing. So, and I don't think that's going to change. It's very interesting. What I know about mental health conditions is that the older a person is, the more intractable those mental health conditions become. And personality disorders, specifically narcissistic personality disorders, are some of the least treatable conditions, particularly in people over 30. So it is the true exception to the rule who is amenable to treatment after age 30. I think I recall in my years of practice, one client who had enough personal insight into their own mind that they were able to undergo treatment, because typically borderline personality disorder, and particularly narcissistic personality disorder, the people have absolutely no ability to see themselves and to have that kind of insight. And so treatment becomes very, very intractable, and those illnesses become very ingrained. And I think that in my experience, I remember one client in particular who made some really remarkable progress in therapy, and she had been diagnosed with personality disorder, narcissistic personality disorder, but she was the 1%, and her therapist was very quick to point that out. And they also often relapse back into the old patterns. So I don't think we're going to see Lori make any substantial changes at all. I think she is who she's going to be for the rest of her life. But fortunately, she's going to be doing it behind bars. Hey, flashback. Question: is it usual practice to order potential witnesses not to attend or watch the trial? In Perry Mason days, the actual killer was in the courtroom. That is very true. But I think even in Perry Mason days, it was very typical to have witnesses excluded. But it made for much better script to have the murderer in courtroom. It is very typical to exclude witnesses from the trial. It is getting more and more difficult now that trials are being live streamed to really have much control over that. But judges direct witnesses not to watch the live stream, not to attend beforehand. And I mean, it's much easier when you know all your witnesses and you can look around the courtroom and say, oh, by the way, I have witnesses in the courtroom, but it's not so easy when it's being live streamed. I will say that one of the reasons I am a lawyer is because I blame it on the measles. This is in the foreword to my divorce book, but when I was young, I grew up before there was a vaccine for measles, and I had a very bad case of the very bad measles. And as a result, and a pretty bad set of side effects and additional issues afterwards. And so complications is the word I was looking for. And so I spent a solid month on the couch in my living room growing up. And I fell in love with Perry Mason. It came on at that point, it was on around lunchtime every day, and I became a Perry Mason addict. And so I watched a lot of Perry Mason. And then a few years later, when I was middle school age, we watched a televised version of To Kill a Mockingbird. And that was the point at which I was sure that I wanted to be a lawyer. So I blame Perry Mason and the measles for inspiring me. And then I really blame Atticus Finch. So I have a beautiful framed piece of art made out of a paperback version edition of of To Kill a Mockingbird, and it will go up behind my desk at the new house in Bend. So you know, I have to admit that my husband and I have not been super excited about hanging pictures and all those sorts of things here in Idaho, because we felt like this was going to be temporary from the beginning. So so there you are. So we're right at the 1 hour mark, and we've talked about the things that I really wanted to visit about tonight. So if there are no other questions, I will wrap it up for the night. I want to say once again, thank you so much for the super chats. Thank you so much for joining us tonight. It's always fun to spend some time with you on a night other than Wednesdays. And I am happy that we are going to be able to continue to do this. If you have not downloaded your pattern, please do so. The link is down here for the origami crane quilt for Kay and Larry. You can, I will be doing an instruction video and putting that up. We'll give you all the information about the best way to make those squares, where to send them, but you can send them to my P.O. box, which is also in the show notes. Thanks so much for joining us tonight. Thanks, Jen, for hopping in on an off night. And I am wishing you all a great week. Have a wonderful week. And I'll see you. Have a great weekend. And I'll see you on Wednesday.